Welcome to the Roetzel HealthLaw HotSpot. HealthLaw HotSpot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the HealthLaw Hotspot. I'm Ericka Adler, shareholder at Roetzel & Andrus and leader of the healthcare practice. Today, I'm joined by two of my partners, David Hochman, also part of the HealthLaw practice and a shareholder at Roetzel & Andrus. He also heads up our Chicago office. Donna Hartl's with us as well. She's a shareholder at Roetzel & Andrus, and she's the practice group leader for the tax group. Today, we're talking about an important, though not necessarily exciting topic of employee retention credits. For those of you who don't know what this is, this was yet another tool that was included in the CARES Act, which came out of the COVID pandemic. So what we really want to talk about today are some of the questions that we're getting from our clients, which is, what is the employee retention credit? Do I need it? And how do I get it? So thanks for being here, and we can't wait to hear all about it.
Thank you, Ericka. The employee retention credit is something that's kind of creeped up on people because there were so many restrictions on it initially, like if you got a PPP loan, you couldn't get it. And those restrictions have since been lifted. So now it's available to so many more people, and that's why we're getting so many questions on it. What it is it is a credit that you can take on your employment tax return. So the return where you're paying over your withholding and paying over the Social Security from for your employees, you can get a credit on that return for both 2020 and 2021 if you meet certain requirements for the time periods. And the requirements are different in 2020 than they were in 2021. So, for example, in order to qualify for the credit and the amount of the credit, in 2020, the credit is equal to 50% of employee wages up to 10,000 of wages, so $5,000 per employee for the year for 2020. You take it on your Form 941, which is the form you use to send over your employment taxes. And you qualify to use that if you were shut down or partially shut down due to a governmental order, or if your gross receipts were 50% or less than they were for the comparable quarter for 2019. So if you meet either of those tests, then you can qualify. The second area to look at to see if you qualify is how many full-time employees did you have on average in 2019. If you had 100 or less, then you get the credit irrespective of whether or not the people you're getting the credit for actually perform services during that shutdown period. If you have 100 or more full-time equivalent employees for 2019, then you can only get the credit against wages you paid people while they weren't performing services. So it's a pretty complicated flow chart to go through, but if you qualify, it really could be a significant amount of money to people. In 2021, they lowered a lot of the bars. So whether or not the employee worked during that period or not is raised to 500 from just 100 employees. And more importantly, if you qualify, the amount you can get per employee is 70% of their $10,000 wage cap. So you can get $7,000 per employee, and a big difference, it's by quarter, not just for the whole year.
Oh.
So the amount is significantly more, but you still have to pass the test by quarter of were you shut down or partially shut down, or did you have a significant drop in your gross receipts. For 2021, that significant drop is only 20% as opposed to 50% for 2020. So it's a very mathematically intense formula. And usually what I do is, as I'm talking to clients, just say, have you looked at the employee retention credit? let's talk about it. Let's see if you might qualify. And then we also pull the accountants in to kind of work the math. Where I see a lot of issues with the healthcare practice is many people in the healthcare practice didn't have the significant drop in revenues. So the question was, were they partially shut down because of a government order? And that's where the many rules kick in. A government order on its face sounds pretty easy to define, but in the medical space, it isn't just the governor's order. There's questions of whether or not, for Illinois, the Illinois Department of Public Health orders were enough to say it's a partial shutdown, for example, for elective surgeries. The IRS has put out a notice 2021-20, which is kind of the Bible right now of what all the rules are. And it's over 100 pages. But it's, it's indexed and it goes by topic. So it's actually easier to navigate than you think.
Right.
But the issues of whether or not a healthcare practice is partially shut down is still ill-defined. It gives examples of when a hospital is partly shut down. It gives examples of when a vendor being shut down hurts your practice, but it doesn't quite cross the bridge. And so the question that a lot of healthcare people are asking today is, can I use a government order of not electing surgeries or not doing elective surgeries? Can I use that? And frankly, that is the question today. And I can tell you, some people are taking the position they're going to say that it does, and other people are taking the position they're going to wait to see if that 100 pages becomes a little longer.
Well,
which
what happens?
Probably will.
What if they take that position and somebody disagrees down the road? Is it merely that you get denied the credit, or is there worse?
Well, chances are, if it gets denied, it's going to get denied a lot farther down the road, because right now there is no clarification on it.
Mm-hmm.
And if it is denied, here's the three things you have to worry about. You have to worry about paying the credit back. You have to worry about penalties, and you have to worry about interest. The penalties, I think, because the language is not clear and the clarification has not come out, I think if we put in the file our reasons for why we thought we qualify, put in the governmental orders, if that's what we're relying on, put it in the file, and just a short couple paragraph reason of why we're doing what you're doing, in my opinion, you have a defensible position. So what you're really worried about would probably be the credit itself, having to pay it back, and the interest, the time value of the money in between.
Right.
Yeah.
And some people are waiting and some people are taking it.
Yeah. Donna, can you talk a little bit about, I know that there's some complicated rules about trying to avoid people gaming the system by counting the same numbers twice or same dollars twice?
Yes. What they did with the employee retention credit is what they're doing with all the CARES Act monies. That if, like the Family First monies and the PPP monies, to the extent you need to use certain wages to qualify for PPP forgiveness, you can't count those same wages for those same quarters for those same people for the employee retention credit. What they don't do is they don't let you double dip. But because the PPP loan extended the period in where you can count wages and non-wage expenses to qualify for forgiveness, that many people are finding it easy to manipulate the chart on which wages you use for which part of the CARES Act. So again, it's math intensive. It would need working with your accountant to make sure, but it can be done. But what they don't want you to do is, if you only qualify for one quarter and you use that quarter because you needed it for the PPP loan forgiveness, you can't use those same wages, those same people again for the employee retention credit.
So I don't know if you've answered this question, but if a physician's salary is more than the maximum dollar amount we can count for PPP purposes. That extra salary can be used to qualify for the ERC?
So long as he's an employee, yes.
Yes. Okay.
And as long as you document what you're doing, because if you're ever going to have this looked at, you need to prove that you did look at it, and you can prove that you didn't use the same wages twice.
I think this is one of those situations where you have to keep good notes on what you're doing so you can go back and explain it to somebody 2 or 3 years after the fact.
Correct.
If you have to.
Correct.
And it seems so complicated. I mean, unless a practice really has the money to go out and pay an accountant and pay a tax lawyer, whatever, to go through this with them, then they're leaving money on the table, right? And even then they may need to defend it later on. So is it worth doing?
I think you, as a threshold, you run the numbers in your head. If you have a lot of employees for a particular quarter, and if you really were affected, especially in 2021, $7,000 per employee could add up to a lot, and will add up to more than legal fees and accounting fees. If you've only got one employee, that's a different story. But one of the takeaways in this 100-page document is keep good records of what you're doing and why. And you don't have to take the credit on your employment tax return when you file it when it's due. You can go back and amend later. So some people are waiting to see if there's a little more clarification, and they'll just amend later. And some people are going ahead and taking the credit. So it's there's no good guidance in the healthcare area of what's a governmental order. So, well, here's another suggestion. If your gross receipts dropped either 50% or more in 2020 or 20% or more in 2021, then I think it's an easier decision. Take the credit, because it's an either or. You don't have to have a governmental order and a drop in gross receipts. You only need one or the other.
Great.
So what taxes can you claim the credit against? Has that changed?
Kind of. It is against the employer's share of FICA is what the rule says, Social Security. For the third and fourth quarter of 2021, they're changing it, and it's against the Medicare portion of the tax. But how it works is you get a credit against all the taxes you pay on your employment tax return. So if I'm doing an employment tax return for 2020, and I can take up to $5,000 credit against wages, the employer's share of Social Security, if that's only $1,000, I still get the $5,000 credit. But the way it works is it's a refundable credit, meaning $1,000 is applied against the employer's share of Social Security, and that extra $4,000 gets refunded to the employer as an actual check.
Okay.
Well, it sounds like our clients definitely need to talk to someone like you, Donna. And, hopefully, if they reach out to me, I'll be sending them your way. This is a little bit out of my area, but, coming out of COVID, we need to look for every opportunity to get our practices and all of our employers back to where they were financially when possible. So we don't want to leave money on the table either, if this is free money, so to speak, right?
Well, yeah, and the takeaway from this is when the CARES Act first came out, very few people went for the employee retention credit because they said, if you got a PPP loan, you can't go for it. And then they extended it into 2021. And then they came out with clarification. And then they upped the ante for 2021 and eased the rules. So it slowly creeped back in to be something worth looking at. And they got away the requirement that you could have PPP loan monies and the ERC. So that's why it's been overlooked, because it started out as an either or proposition, and it's no longer either or. So when I talk to people, even if we're not talking about ERC, I do bring up to the clients, have you looked at it? Because a lot of them are looking at it now, and a lot of them are determining whether or not they qualify.
Great. Well, we hope that they'll continue to reach out with any questions. Stephen, any final thoughts on this topic?
One more question, Donna. Now, this program is administered solely by the IRS. So unlike the PPP program where the SBA and the IRS sort of had to work together, it seemed like every 3 days there were a new set of most recent questions and answers. It doesn't seem like that same lack of decision making is going on as far as the administration of this program. Is that a valid assessment, you think?
I think there are
I know you don't have
similarities.
all the answers.
Yeah, I mean, I think there are similarities. There's similarities with the PPP in that the clarification keeps dribbling out, and every time clarification comes out, it raises 10 more questions. So there is similarity in that vein. I expect that things like the gap of what's a governmental order in a healthcare situation is going to be clarified, because I have found with the PPP, as people kept asking the same question over and over, they finally got addressed. So I think we're still waiting for that, but I think it's going to dribble out. I think it's going to dribble out over time. And all we're doing is, I can say that the Roetzel's on top of it, and we're keeping track of things as they come out, and we're ready to talk about it if anybody has questions.
Great. Well, that's a good way to sum it up then. Does anybody have any final comments? No? Yes? No?
I would say don't. I think it is given that you should at least ask about it, either your attorney or your accountant. Yeah, there was one more thing. In this notice that came out, the 100-pager, there's one more rule, 10%. For you to be partially affected, partially shut down, you either have that part that was shut down has to be at least 10% of your revenues, or has to be 10% of the hours worked by your employees. And that's actually pretty new. That was not stated before.
Great. And I guess, I'm not sure how that would apply to, well, what do they mean by part? Do you have any idea?
Elective surgeries. You can look at what your elective surgeries were before the pandemic, and look at what they were in the quarter we're trying to get the credit for. And if your elective surgeries were 10% or more of what you did, then a partial shutdown of elective surgeries qualifies for a partial shutdown if the government order also qualifies you for a partial shutdown.
So we got to really look at a practice and see, what can we, partial.
Right. If you only do one elective surgery a quarter, it's not going to help.
Right. Got it. All right. Well, that's really helpful then. And certainly for medical practices that, surgical practices in particular that really lost that revenue. This could be
anesthesiologist.
Yeah. Anesthesiologist, gastro, where they couldn't do endoscopies or colonoscopies, orthopedic surgeons, plastic surgeons. So, really this could be somewhat helpful, if not entirely helpful, for them to look at. So, all right, great. Well, thanks both of you as always for stimulating discussion on an excellent topic. But I know it'll be really helpful to a lot of people out there. I mean, there's still a lot of practices just recovering who still aren't back where they were before. But hopefully as this pandemic kind of winds up in the coming months, they'll be looking more closely at how they can get themselves back in a good financial position.
Yeah, the takeaway is there's something else out there that's become more liberal over time, and you should at least ask about it.
Right. Great. All right. Well, thanks everyone for joining us.
Thank you.
Thank you.
We hope you'll join us again. You can find out more about our podcast at healthlaw.ralaw.com, and you can reach out to any of us and ask us questions. You can find our biography and contact information at ralaw.com. Thanks for joining us.
Thank you.
The Roetzel HealthLaw Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel HealthLaw Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel HealthLaw Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.